Crypto company BlockFi is filing for bankruptcy. The cryptocurrency company BlockFi filed for bankruptcy, making it the next cryptocurrency domino to fall after the failure of FTX 2 weeks ago, which posed a threat to destabilize enterprises operating in the broader crypto ecosystem. Hey guys, welcome to our channel Fast Forward. In today's episode, we are going to tell you why crypto company BlockFi is filing for bankruptcy. Let's dig in. BlockFi is a cryptocurrency trading exchange that also provides a custodial service that earns income for its customers' cryptocurrency holdings. The financially troubled business, which had previously stated that it had substantial exposure to FTX, disclosed that it has more than 100,000 creditors and that its obligations and assets range anywhere from $1 billion to $10 billion. The continued impact from the FTX scandal, along with the bankruptcy earlier this year of lenders Celsius Network and Voyager Digital, are providing crypto investors with a harsh education regarding the safeguards they have in comparison to investors in more traditional asset classes. Their financial future is currently dependent on the outcome of the legal actions, which are expected to take a number of years to resolve. According to the opinions of several legal authorities, virtual currencies like Bitcoin and Ethereum, along with other types of digital assets, fall into a regulatory limbo in the United States. Because of this, they are exempt from the majority of the scrutiny that is applicable to holdings such as stocks and bonds. In addition, federal funds are not readily available to back up customers in the same way that they would be for individuals who had shares at a failing brokerage firm or a bank. The answer can be found in a case that was heard by the Supreme Court in 1946 concerning investors in orange groves in Florida. In the case SEC v. W.J. Howey Company, the judges who heard the case developed the so-called Howey test to assess what qualifies as a security, often known as an investment contract. The Howey test will be discussed later on in this video. Shares of publicly traded companies are classified as securities and are subject to oversight by the Securities and Exchange Commission of the United States. The Howey test has been used by the courts to bring certain non-traditional investments such as animal breeding programs, railroads, mobile phones, and internet-only businesses under the umbrella of investment contracts. This has the effect of providing these investors with the same level of protection and oversight as stock investors. The following explains why this is significant for crypto. According to the Howey test, which dates back 76 years, it is frequently unclear whether digital assets qualify as investment contracts. According to Richard Painter, a professor of security law at the University of Minnesota, the control provided by regulatory agencies is therefore rather unclear. Some industry professionals have pondered whether it would be more acceptable to consider cryptocurrencies to be a currency or a commodity, both of which are regulated by distinct federal agencies. Painter, a former White House ethics lawyer under President George W. Bush, stated that it doesn't make any sense to have all of this turn on the Howey test in the 1940s-era case, he said. He characterized it as an open invitation to catastrophe. The story has to be told by somebody. We know what happens with unregulated markets ever since the 1637 tulip bulbs mania in Holland, added Painter, referring to an event that is widely regarded as the first documented case of a major financial bubble that resulted in the bankruptcy of a number of investors. We know what happens with unregulated markets. In order to assess whether or not something like Bitcoin is an investment contract, the Howey test consists of 4 separate aspects. If all of the following are true, then there is a contract. There is an investment of money in a shared enterprise in which the investor expects to make a profit, and the benefit is completely generated from the labor of other people in the enterprise. Consider, for instance, an investor who possesses publicly traded shares in their portfolio. The investor is not the one who does the work to generate profits for the firm. Rather, the employees and managers of the company are the ones who do the labor. For their part, investors tend to gain profits in the form of dividends and/or an increase in the share price of the company's stock. However, crypto is not the same. Daniel Gwen, a corporate restructuring counsel at the legal firm Ropes & Gray, explained that in many instances it is decentralized, which means that it may not be regarded as a common enterprise. Gwen claimed that some people use it to transfer money over international borders or as a store of value. Thus, it is unknown whether or not its primary purpose is to produce a profit. It is also unclear whether or not its intent is always to generate a profit. The Howey Company, which grew orange groves and solicited investments from visitors staying at the nearby hotel, was at the center of the case that was heard by the Supreme Court in 1946. The investors' needs were met by a partner organization that managed the forest. Following the completion of the orange harvest, Howey distributed a portion of the total net revenues to each purchaser. According to the court's decision, the transactions unequivocally involved investment contracts. According to Micah Humpton, Director of Investor Protection at the Consumer Federation of America, an advocacy group, the SEC would have the ability to oversee enterprises that are not complying with securities regulations if crypto were also a clearly defined security. According to him, this kind of enforcement might also have the effect of discouraging would-be criminals. Investors would be subject to additional disclosure requirements in addition to any other safeguards that might be in place. Hopman stated regarding cryptocurrencies that despite the fact that it shouldn't make a difference to investors how these assets are regulated, it does in reality make a difference. In certain instances, the SEC has made an effort to assert its regulatory oversight authority. For instance, the government filed a lawsuit against Ripple Labs and its officers in 2020 for failing to register XRP as a security offering, even though it was a cryptocurrency. That investigation is still going on. Sheila Bair, a former chair of the Federal Deposit Insurance Corporation, was interviewed by CNBC and said that she did not believe that regulators were to blame for what occurred at FTX. They have been urging Congress to intervene because there is not a lot of clarity, complete clarity, about what should be with the banking regulators and what should be considered a security and what should be considered a commodity. It's been said that the law is all over the place. Customers who store their cryptocurrency holdings with FTX do not, it would appear, have the same level of financial security as customers of defunct brokerage businesses that sold stocks, bonds, and other types of securities. In the event that a brokerage firm goes out of business and the investor's holdings are encumbered by the insolvent firm, the Securities Investor Protection Corporation will indemnify the investor for up to $500,000 of their losses. Take, for example, a client of Lehman Brothers, who at the time the company filed for bankruptcy held shares of a publicly traded company's stock in their portfolio. According to what Gwen had to say, the objective of SIPC would be to place shares back into the possession of investors as soon as possible. In the event that a bank fails, clients are protected against losses of up to $250,000 by the Federal Deposit Insurance Corporation, or FDIC. However, according to Gwen, it's quite unlikely that FTX clients have SIPC protection. To start, this protection only applies to securities, which means that crypto's ambiguous status, as either a security or a non-security, could be an obstacle. There is a possibility that FTX may not qualify as a brokerage, which is a business that deals with various types of securities. Painter stated that the SIPC does not cover the company since it is headquartered outside of the United States, namely the Bahamas. Gwen explained that FTX operates in a manner that is analogous to that of a broker-dealer. However, when it comes to crypto, the legal landscape is a complete mess. On November 11th, FTX submitted their petition to reorganize their business under Chapter 11 of the Bankruptcy Code. Customers who own crypto assets must keep their fingers crossed that they will be able to reclaim part of their money, if any at all, during the bankruptcy process. It's possible that this will be a challenging and drawn-out process. Gwen stated that Chapter 11 is not actually designed to defend this case, which refers to a situation in which an uncertain digital asset is being controlled almost in the same manner as security, but without the same framework. It does not imply that investors do not have any protections. Rather, various protections are available to investors. So that's it. I hope you enjoyed watching the video. Stay tuned for more wonderful stuff. And don't forget to like our video and subscribe to our channel so that you don't miss any of our recent updates. Thank you for watching.